All right, we're launching on YouTube. All persons having business before the Honorable Associate Judges, now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and its Honorable Court. This Honorable Court is now in session. Please come to order.
Thank you. Good morning, everyone. Welcome to this oral argument before the District of Columbia Court of Appeals. As you know, the COVID-19 pandemic has caused all of us to make adjustments. The court is in the same position. We've needed to make adjustments to ensure access to justice. And so what we've had to do is to modify how we conduct oral arguments. We are now proceeding with oral arguments via remote video conference. They will be live streamed for public access. Our court staff has made every effort to prepare us and to prepare counsel for proceeding in this way. But inevitably, there will be glitches, I think. And so we will need to exercise patience with this new technology. The public will be able to view the arguments in real time at the DC Court of Appeals YouTube channel, which is on the court's website. Counsel, if you're ready, you look like you are. I will call our first case, and it is number 18TX1321, Accenture Sub Inc. versus District of Columbia. I believe, is it Galland?
Lipinski Galland, but Galland is fine, Your Honor.
Lipinski Galland, thank you. You may proceed.
Thank you, Your Honor. Obviously, Stephanie Lipinski Galland for the appellant in this matter, Sub Inc. We specifically appeal today the ruling, the February 8th, 2019 ruling and the Superior Court judgment in favor of the District of Columbia in this matter. Specifically, the denial of the refund applied for by Accenture to the Office of Tax and Revenue. The court, there's a question about timing that has been brought up by the District of Columbia. So I think I will address that first, because obviously if the court does not have jurisdiction, this case goes nowhere. So the district basically said that the appeal that was filed by Accenture was not timely filed, and said that they proposed that the January 23rd, 2018 judgment was the final judgment. Obviously, Accenture disagrees with that and says that the February 8th, 2019 entry on the docket of the judgment was the final entry of the judgment on this matter. We need to look at the facts on this. For now, if you look at the transcript that the trial court judge did on 1/23/18, he specifically said that I will issue this for now, footnoted it, and indicated there were going to be other information or other pronouncements coming from the court.
But what kind of a pronouncement that is actually matters, right? He sort of ends up kind of backing off and referring it to it as a memorandum, and why doesn't it have the feel of the order is going to be issued and then I'll explain it later?
Well, I think we need to look at the facts, the subsequent facts of both parties, both the District of Columbia's attorneys and Accenture's attorneys at the time. If you look at it, the negotiations under Rule 14 continue on. Both parties sit and negotiate how much are we going to settle for? How much is actually going to be paid or not paid? And we have three DC attorneys.
You call those, counsel, you call those negotiations under Rule 14. Rule 14 isn't really about settlement against the risks of losing on appeal or the like. Rule 14 is about calculating the amount that is going to be owed by a party pursuant to the court's order. And was there any need for negotiation pursuant to Rule 14, meaning Now the court has indicated its decision, its reasoning, but somebody's got to do the math of figuring out what that means in terms of who owes what to whom under the court's decision.
Well, sorry, Your Honor.
No, go ahead. Thank you.
And this delay is causing us to talk over each other, which I generally and most affirmatively do not want to talk over judges. Rule 14 under A says pursuant to the court's determination of the issues. Clearly, the court had made some determination of issues in the January decision that it had made, or the opinion that it did, clearly made some determinations of the issues. What happened specifically is both parties truly believed that the final opinion had not been issued. 3 attorneys from the District of Columbia all said this. If you look at Clayton's declaration of November 30th, 2019, Ludaway, who's the chief deputy counsel, said they were not in a position to make a counteroffer without the benefit of Judge Fisher's opinion. There were 2 other, Betsy Cavendish, who was the executive general counsel to the mayor. She also affirmed that. And then Attorney Wood confirmed that it was his understanding that the opinion from the court was forthcoming. And that was October 30th, 2018.
It makes perfect sense that if the court has issued, the trial court has issued its ruling, and everybody knows under that ruling, Accenture sub is not entitled to any refund, so the number is 0. Nobody needs to do any residual math. And people are negotiating about, well, can we settle this because there's a risk of appeal, and so we need to settle it under an order where everybody knows what's going to happen if there isn't a settlement. It makes perfect sense for the parties to be saying, well, we can't really figure out whether we want to settle this or not settle this until we know what the rationale of the trial court is. That will help us figure out how strong a ruling is, how not strong a ruling it is. And so I'm not quite sure I draw the same inference you do from the fact that there were discussions about, we can't really figure out how to settle this or not unless we see the benefit of the later explanation of the court's ruling. That doesn't seem necessarily to tie into finality in the way that you're suggesting.
Well, Your Honor, this also goes to another fact. So assume that this court says that the January 23rd ruling was the final ruling, was the final opinion, the final judgment, notwithstanding the court's subsequent one I beg your pardon, the timing, on February 8th, 2019. This goes to the Frayne and then Frayne from this court and Hamner argument of the US Supreme Court that basically said that if there is a reasonable, there's a relief valve under Circle, Frayne, and Hamner, when a motion is filed beyond a fixed time, a party may be relieved from the consequences of that timeliness of a filing if it was lulled into the untimely filing by some action of the judge. And this goes back to the reasonableness issue that's brought up in Frayne and also brought up in Hamner from the US Supreme Court. One of the issues is, did the appellant actually have reason to believe in, and DC lawyers, 3 attorneys have never said anything. There was no objection. There wasn't, sorry, we can't do this, nothing. They were in total conformity with what the appellant believed. And if you look at the Frayne, Hamner, was the appellant lulled into a sense of belief that a final determination was coming, and that led to the untimeliness? Clearly, under Hamner and this court's decision in Frayne, that has happened here. Whether or not the court believes that it was the 18 decision or the 19 decision. The 19 decision, it's clean. The 18 decision, was there something, an action, affirmative action by the court that could lead the parties, and in this case, we have evidence that it did, to believe a final opinion was coming down.
Let's assume that we can get past the jurisdictional issue in one way or the other. Why don't you move on to the merits, unless one of my colleagues has further questions about jurisdiction?
Yes, ma'am. Thank you. The main argument here was the denial of the refund. All of the appeal points are obviously in the brief. We don't have enough time to go through all of them as is appropriate. But the main points on this is that the trial court erred by failing to apply the law to the true facts, that the basis of the underlying assessment was wrong. The underlying assessment was for nexus that created tax nexus for the appellant was based on two facts. One fact was somehow or another that the sub had 2 employees in the District of Columbia, and that somehow there was control, proof of common control. At no time did the District of Columbia bring evidence that showed proof of common control, that there was any kind of common management, nothing. That's not in there. If you look at the conferee's transcript, she specifically, who was the conferee that this thing moved on before the trial was done, but after the assessment, said, I'm basing my position, which is coming out of the conferees, on the fact they have 2 employees and common control. In discovery, we find that the joint stipulations and other declarations by DC employees from OTR, they specifically say we were wrong. Sub did not have 2 employees in the District of Columbia, and they never showed common control. They showed no indicia of it. They didn't bring up anything that the person had common management. They didn't say that they had common bank accounts, common board of directors, none of that. And that is clearly in Supreme Court jurisprudence that to show this unity or the unitary principle, you have to show common management. You have to show common control. And the district.
Can you clarify? I'm sorry. Can you clarify something for me? I understand that sub and LLC, it's hard to keep all these straight, don't have any direct interaction with the district. But one thing I'm unclear on is to what extent does LLP do business in the district? What is, how extensive is that?
LLP is a consulting entity that basically does consulting, mostly for government agencies, although it does have other clients and stuff in the District of Columbia. It is physically in the District of Columbia. The office is in the District of Columbia. They have property, payroll, and sales in the District of Columbia. So yes, LLP is without a doubt in the District of Columbia. Sub has never said that LLP is not in the District of Columbia. The confusion comes from the fact that in trying to bring sub in, OTR says we have to find taxable nexus, which is a bedrock of US Supreme Court jurisprudence having to do with state taxation. And for purposes of state taxation, even though the district is not a state, it is enveloped within the state principles of state taxation. So you have to have nexus over the people that you are planning on taxing and bringing in. The District of Columbia, and is also precluded under federal law from taxing non-residents. The statute in the code in the District of Columbia, it speaks to individuals. It does not speak to corporations, right? On how individuals are supposed to recognize DC income, if at all. But here's our problem. LLP is a limited partnership. It is not directly owned. It is one of the partners in LLP is not Sub. Sub is a second tier partner, passive investment partner down, and the structure chart.
Can I ask you about that?
Yes, sir.
I have a question about that.
Yes.
The intervening layer is Accenture LLC. Is that correct?
You know, Your Honor, I don't have a copy of the chart sitting in front of me. I do apologize.
Do you know the intervening owner, I think, is Accenture LLC, and I understand it.
It's a partnership.
Yes, and I understand that for purposes of federal tax law, it's undisputed that it's sort of a pass-through entity and it's disregarded for federal tax purposes. Is that correct?
Yes, sir, it is. But here's
one. Is the same true? Is the same true under DC tax law? That it's sort of disregarded for DC tax purposes or only for federal tax purposes?
For federal purposes only, Your Honor. Here's one of the problems. The District of Columbia, in order to be in compliance with what the federal restrictions are on the application application of DC tax law to non-residents, has created an unincorporated business tax that it says we know that we can't tax partnerships and grab the partners and bring them in. So we have created this UB, unincorporated business tax, and you are going to be in there, right? And if you're an unincorporated business, a pass-through business, anything that qualifies as under Chapter K, you are going to be in that unincorporated business regime. And here's part of the confusion is that the district is trying to have its cake and eat it too. It wants the unincorporated businesses to be subject to the UB tax, but then it says, yes, if you can't be an unincorporated business, and here's the other point in this whole matter, Your Honors, there's a thing called a QHTC, Qualified High Tech Company in the District of Columbia. Specifically, the law says you can't be an unincorporated business and be a qualified high-tech company. But the district forces partnerships on pass-through entities to file, during this period in time, to file a UB return and pay the tax, the minimum tax. But then it says all your other income under the QHTC is now gone. It's forgiven. So if the district is saying that, no, you can't be a UB, because you can't file a UB because you're an unincorporated business, and you can't, qualified high-tech companies, excuse me, can't be an unincorporated business and file a UB return, you've got to file a partnership return, then all of the benefits that go with that QHTC must flow. So the district can't have it both ways. It can't follow the federal procedure and say, yes, you're a partnership, and you can't file a UB return, you can't pay any of the UB tax, so you're going to have to flow this through to your partners. We're going to grab your partners and bring them in, but you don't get any of the benefits as a qualified high-tech company, but we agree you're a high-tech company.
Well, I'm not
I
sure
was
that-
going to ask you about your nexus and minimum contacts argument, and
Yes, ma'am.
it could be that I'm missing a fact here, but the briefs tell us that your client paid the tax over several years, obviously paid because that's the reason for seeking a refund. And one would think that if you thought there were not the minimum contacts to permit the district to impose that tax, that someone would have protested long before they did. Did something happen?
Yes, Your Honor, it did. I am out of time.
Not proper to object before, but proper to object now?
Your Honor, I am out of time. Can I answer the question?
Big answer, yes.
All right, thank you. Here's what happened, and it's in the brief. Accenture thought that there was one protocol or one process that needed to be followed. The District of Columbia came in and audited the whole group of Accenture companies, and including at that time Sub, who was filing the D20 within the district. The district comes back and says, you can't do that. LLP is supposed to be, because LLP's income was flowing through, Accenture Sub was filing a return recognizing that income. District of Columbia audit comes in and says, you can't do that. LLP is supposed to file an unincorporated, a UB return, and Sub, you're not supposed to be filing a return at all. So we did exactly what they told us to do. And because with pass-through entities, you pay tax on the income once, right? What happened is we're now filing a UB return and we have to pay tax on the UB level. Then the D20 that Sub was filing wasn't supposed to be filed. So we went back and filed amended returns for LLP as a UB as instructed by the district. And then the money, now of a sudden, the income of LP was now being taxed under the UB protocol. And you can't tax the same income twice. Sub then goes and files for a refund on the monies that they have been paying by recognizing LP's income. The district goes ahead, recognizes that that's what's supposed to happen, gives them the refund for the first 3 years, and then says, holy cramoly, we're losing money. We were making all this money with Sub filing. Now we're not making that because at the same time, the QHTC came in and Accenture realized, LLP realized it could qualify as a qualified high-tech company. And one of the benefits of that is that you don't pay income tax or after a period of years, you pay a reduced rate. So they did that. They qualified. The district let them qualify. So now what's happening is effectively UB is not having to pay tax on its income because of the district's position on qualified high-tech credits. Accenture gets its money back from where it had been filing erroneously. DC is the one who tells them this is what they're supposed to be doing. Now, when DC, and it's documented in the conferee's transcript, if we let them do that, we're not going to be getting taxes. We don't like that. That's not a basis.
Excuse me, I understand that you don't like the district's interpretation, and you have some arguments about what is this QHTC for, if this is the way it's going to play out. But what about the deference argument? Like, why can't the district take a look at this statutory scheme and think, you know what, this is how we've been misreading this, or we overlooked this, or this makes more sense to us to do it this way. Even if it is like, oh, we need to it allows them to get more taxes out of companies like your client, but does that make it a misinterpretation?
Your Honor, I don't think so. I think we need to look, this is like the Chevron/Skidmore defense, or the fact that great deference is to be given a tax department for its interpretation. However, if you look at the Supreme Court case, and I'm going to butcher this pronunciation, and I know it, so I do apologize to the court ahead of time, Scaliaba versus Cellular de Orsario, which is a Supreme Court case that basically said the Chevron-Skidmore defense does not apply when the statutory provisions are directly contradictory. And in this case, you've got a statutory requirement in the district that you can qualify as a qualified high-tech company. And then in another section, it says, but you can't be a qualified high-tech company, can't be an unincorporated business. So, and you've got the district then saying, yes, but you need to file an unincorporated, and only unincorporated businesses can file an unincorporated business return. So the fact that we're supposed to give deference to the district's reading of this would be well and fine in maybe a normal circumstance, but this isn't, because clearly under Scaliaba, the Supreme Court, Chevron and Skidmore defense cannot be applied when the statutory provisions are directly contradictory. And that is exactly what happened in this matter. If the district wants sub and LLP, wants LLP to file as a partnership, which it really can't because of the numericals on how much income it earns, but if they want them to file a partnership return, then the qualifications and benefits of a qualified high-tech company, which all parties agree that LLP is, flows down through. So that's our worst case scenario, is that if LLP has to file as a partnership, then sub, even though it's a second tier partner, not a direct partner, and imagine if you all of a sudden say you can go to second and third tier partners on stuff, what the chaos that is going to cause. And it's not in the statute anyway. But if you say that LLP is a partnership and has to file that partnership return, in spite of what the law says that they're not supposed to be filing that partnership return, then all the high-tech benefits have to flow through to the partners.
Does Accenture, does Accenture Inc. Pay tax on its 1% managing partner share?
Your Honor, I do not know. And I'm sure it's embedded in the stuff. That was not part of this discussion. And I to be really honest, I can't, in all honesty, say yes or no to you.
Okay, thank you.
Did you have a question, Judge McLeese?
No.
It looked like you were about to. All right. Well, thank you, Ms. Lipinski-Galand. We will give you a couple of minutes on rebuttal if you need it. Let's hear from
Yes,
Ms.
ma'am.
Ellie.
Thank you.
Thank you.
Good morning, and may it please the court. Lauren Alikhan for the District of Columbia. I want to start where appellant started, which is that this appeal is untimely. So the operative judgment was the summary judgment that was entered in January of 2018. That was a final order. To be sure, the judge indicated that an opinion would be forthcoming, but it's well established from NAH in this court and a host of federal cases that it's the order that is the operative date for Rule 4 purposes and not a subsequent opinion. And I'd also like to note that to the extent that appellant tries now to resort to some sort of unusual circumstances or equitable tolling doctrine, she did not raise that in her reply brief, and so it's therefore not properly before this court. I also don't think that equitable tolling would be available in any event under the recent Supreme Court decision in nutraceutical and also under the facts of its case. So I think plainly the January 2018 judgment was final, and Accenture Sub's failure to take an appeal within 30 days rendered this appeal untimely, and as a mandatory claims processing rule, Rule 4 must be applied to dismiss the appeal.
On equitable tolling, I understand your point that you think it hasn't been adequately preserved, but what's your response to your opponent's suggestion that it appears from the comments that the district's lawyers were making after what you claim was the final order, that the district's lawyers didn't realize that after 30 days, there wasn't really a need to talk about settlement anymore because, there was a final judgment that hadn't been appealed. It does seem as though the district's lawyers may not have appreciated the procedural point you're pressing on us now.
Frankly, Judge McLeese, the response is precisely what you posed to appellant's counsel. We've been aware of this from the beginning. That doesn't mean that we wouldn't still engage in settlement discussions in the event that there were to be an opinion and appeal, and so we were going to perhaps not win ultimately on a jurisdictional issue or a merits issue. So our settlement position and our continuance in negotiating with appellant had nothing to do with our, waiving any type of timeliness objection. And in fact,
well, no, my point is, I got that for the first 30 days, or maybe with an excusable neglect period a little bit more. But once there comes a time when there hasn't been a timely appeal, the time has run out and there's been no appeal, I'm not quite sure why the district's lawyers aren't saying, there's nothing more that needs to be done in this case. There's an unappealed final judgment. So, we're finished here. It seemed more as though the district's lawyers, perhaps incorrectly, thought that actually there was a further event that was needed before the possible appellate phase of this matter geared up.
Sure. Well, outside the record, I can say as a matter of fact that was not the case, but there are certain exceptions to Rule 4 that allow a judgment to be reopened for a period of 180 days. And so I think until all of those potential exceptions to any Rule 4 would have expired, we were still in a position to negotiate with the appellant. And when the appellant wanted to go and ask counsel whether any opinion was forthcoming, the district had to be a party to those communications because otherwise they would have been ex parte. However, when Accenture Sub moved for this motion for entry of judgment, we vociferously opposed that, said that we believe that the January 23rd, 2018 judgment was the final judgment, and that the court could not reopen that judgment or otherwise issue a new order from which a new appeal time could run. And so we've taken this position consistently both below and on appeal. And so I think
given what the court said from the bench, was there any theory under which the amount owing would be anything other than zero?
Not at all. And I'd like to actually address that, Thompson, in the context of the Rule 14 argument. If you look at the federal equivalent, which is Tax Rule 155, it is quite clear from federal case law that Tax Rule 155 is discretionary. And so where no computation is needed, it's unnecessary. And for that, I would point this court to the Testor case in the Seventh Circuit and also to the Prevail case from the tax court, both which speak to the fact that Rule 14 is not some typical way by which judgments in tax court are rendered, but rather a discretionary sort of ability of the court, if they think that there's a computation that needs to happen, to put that math problem onto the parties and then to ask them to come back with a calculation. But here the question was always whether Sub owed all of the taxes that it had originally paid or nothing. And so there was no need for any computation. And so I think the only way that this court could reach the merits of the appeal is if they were to find some type of equitable tolling. Now, of course, appellant's failure to raise that in response to the timeliness objection in her reply brief forecloses it, because it's the burden of the party seeking tolling to make the record clean. I would like to, though, note, even if this had been preserved, equitable tolling would not be warranted. We're not talking about a situation where the trial court affirmatively misled anybody. The trial court was quite clear at various hearings. I would point this court to Supplemental Transcript 4, which was an April hearing on a motion for summary judgment. At that point, the court said, look, I'm trying to issue a written decision. If I don't, by the next hearing, I'll issue an oral decision in open court. That's what he did at the hearing on January 22nd. And then when the district counsel followed up to say, well, procedurally, Your Honor, what happens next? He expressly said, what I do is I will issue an order. And then I will try to follow up with, I think what he called it is a memorandum. And again, under NIH and federal case law, it is well established that appeal deadlines do not run from memoranda, they don't run from opinions, they run from judgments. And that's what we have on January 23rd. I think that's also confirmed if you look at the document. Since under the tax rules don't incorporate all of the federal rules, all that needs to happen is for there to be an entry on the docket, not even a separate order. And if you look at the docket, and this is supplemental appendix page 8, you'll see it says disposition, summary judgment, date, January 23rd. And even if there needed to be a separate order, we have that order in the January order that he issued. I think there is absolutely no way for the court to reach the merits of this case under In Re NIH and under nutraceutical and the Supreme Court precedent on equitable tolling in the claims processing context.
Well, as we did with Ms. Lipinski-Galan, let's assume that we somehow get around the jurisdictional issue, and let's hear you on the merits.
Absolutely. So first, a couple of responses to questions that were raised to my opposing counsel. Judge McLeese, on pages 6 and 7 of their opening brief, sub admits that as a disregarded entity for federal tax purposes, LLC is also a disregarded entity for district tax purposes, and therefore they are just out of the equation. And so this notion of being a second-tier partner, they are considered and treated as a direct partner for purposes of this analysis. Next, Judge Thompson, as to what changed, I think it's worth unpacking this here because while appellant's counsel sort of gave some of the story, it's not all of the story. Initially, LLP was exempt from the unincorporated business statute because it was rendering personal services as a significant portion of its business. And so what happened was the LLP would file its partnership return, and then its individual partners would pay district income tax to the extent they were district residents. LLP decided to restructure, Accenture kind of globally decided to restructure, the consequence of which is rather than having individual partners, they then had corporate partners. That meant that they no longer qualified as an unincorporated business under the statute. And so that meant that they were subject to the unincorporated business tax. At that point in 2005, OTR audited Accenture LLP and sub and said, what's going on here? So LLP at that point discovered this QHTC statute. Now the QHTC statute, like the personal services exemption, is something that takes you outside of the unincorporated business realm. So by virtue of being retroactively certified for QHTC status, that put LLP back in the position where they should have been filing a partnership return, and then their partners here, Inc. and sub, would be responsible for franchise taxes on their share of the distributed income. And so it isn't that anything changed. It's that there was an evolution of how LLP was structured, and that restructure had consequences. And then because they tried to retroactively claim and were given QHTC status, it essentially put them back in the situation where the forms they had originally filed were now correct, just for a different set of reasons. And that's
I follow all of that, but it does remain a bit of a mystery why, if that's the correct analysis, a refund was given to Accenture sub for 3 of the tax years at issue.
To be sure, they were not entitled to that. OTR made a mistake, but Accenture is not allowed to capitalize on that mistake and suddenly stop the OTR from applying the actual statute as written in the years going forward. And I think
that's probably true, but my question, I guess, the point of this question is what the implications it may have for our giving deference to OTR. If the issue is OTR, these are tax statutes that OTR administers, and if it gives a reasoned explanation for its interpretation of the relevant statutory and regulatory provisions, then this court owes some deference. If there's an unexplained inconsistency in what OTR has done, it has given a refund for some years and not for other years, and nobody's explained why. Does that affect whether we should be deferring to OTR because we don't know what its thinking is, because it doesn't seem to be applying a coherent theory? Or does that mean instead we need to send it back, or we should be deciding without deference to OTR?
So a few responses, Your Honor. First, deference is not needed here because the plain language of the statute is clear. The QHTC regime gives a corporate franchise rate benefit to incorporated QHTCs. For unincorporated QHTCs, merely takes them out of the realm of being an unincorporated business and puts them into this partnership status, akin to when Accenture was trying to claim the personal services exemption. And so I think deference doesn't need to enter the equation. Next, to the extent you want to give deference, it would be to the current interpretation of OTR, which has been consistent since 2014. And that is because that interpretation is the only interpretation that accords with the statute. It's well established that this court does not give deference to interpretations that are inconsistent with the statute. And it is quite clear that OTR's prior interpretation of this statute did not actually hew to the statute's text because it was failing to understand the critical difference between incorporated and unincorporated businesses as it applied to their QHTC status.
I
Can I
guess
ask
that's,
you,
if we can,
on the-
I'm sorry.
No, go ahead. No, go ahead.
It's clear, I mean, it's clear that you can say that as you're litigating this case now, but it wasn't clear to the trial judge, who said something like, for reasons that are a little bit unclear from the record that is before me, the District of Columbia agreed to refunds and then didn't agree to refunds. And I guess the idea is just, if we're going to defer to something, we want it to have been thoughtful. And I think BAE speaks about this, or there being a good reason. And it's not, is it clear from the record that the district was basing this change upon a good reason?
Absolutely. So I think there are probably three sort of factual pieces under this. First, OTR clearly admitted before the trial court that it made a mistake. And so while the trial judge said, for reasons unclear to me, they gave these refunds for tax years 01 to 03, I don't think that's significant. And so I also think, going back to my first response to Judge McLeese, we don't even need to touch deference here. All you need to do is look at the plain language of the statute. It's only if the statute is ambiguous that we start looking to deference. And so I think next on that point, the deference I think would have to be owing only to the interpretation of OTR that squares with the statute. And that is the determination of OTR from 2014 onward that the QHTC status works differently for incorporated businesses than unincorporated businesses.
Can I ask you, leave aside for a minute plain language, what is your explanation about why the council logically would have wanted to have quite disparate treatment for the QHTC tax treatment of unincorporated businesses and incorporated QHTCs?
So just to put my marker down, I believe the plain language is clear, so we don't need to resort to legislative history, but to the extent we do, the legislative history answers the question of the council's intent, Your Honor. So it's very clear under the legislative history that in order to get corporations to come here, they needed to get some sort of franchise tax rate benefit. And so what the council determined to do was to give a 6% benefit and then to give a 5-year hiatus to companies that located in particular redevelopment zones. Now that 5-year tax holiday was ultimately extended to all corporate QHTCs. But for unincorporated businesses, the concern that was raised, and this comes, I think, from both the Aiken Gump testimony and the Tim Hart testimony, and so this is SA 71 and 76, I think the concern was that out-of-state individual investors, if QHTCs were unincorporated QHTCs were under the UB regime, those would be subject to entity level tax by the district. And then the individual investors might not be able to get a tax credit for that because most states don't treat partnerships or unincorporated businesses as taxable entities in their own right. And so there was this concern that an individual investor would be subject to double tax, where the unincorporated QHTC would be subject to the unincorporated business franchise tax in DC, and then the individual outside investor would be subject to tax on that income, even though it had already been taxed at the district level. And so the legislative history is not trying to put the unincorporated businesses and the incorporated businesses on equal footing. In fact, the legislative history is also quite clear on that point, that for incorporated businesses, the franchise tax rate in Virginia was 6%. And so it was very important for incorporated businesses to have parity with Virginia to draw them into the district, or at least not disincentivize them to locate to the district or to leave the district. And Virginia and other jurisdictions don't tax unincorporated businesses. And so necessarily how the QHTC statute treats unincorporated businesses is going to be quite different, and it's going to be animated by different tax concerns.
I think I follow much of that, I hope, or at least some of it, but your opponent argues that perhaps as an unintended consequence of all that, you end up with a regime where there's sort of double non-benefit, so that the legislature ends up by maybe trying to solve one problem, it creates another problem that your opponent argues is pretty irrational, which is that the ability of an entity to get the franchise tax benefits of being a QHTC ends up practically evaporating under the district's interpretation of the relevant statutes. That there's really no logical legislative purpose for depriving any of the entities that are participating in a QHTC that happens to be unincorporated from one of the principal benefits that the legislature was trying to accord to QHTCs. What's your response to that policy argument? Other than, I know you have your marker that it really doesn't matter because the language is so plain, but beyond that.
So respecting that marker, and with the caveat that no statute, goes to at all costs, I would say just a few things. First, the council was worried about, and in accepting QHTC, unincorporated QHTCs from the UB statute, was thinking about individual investors. They were not thinking about partnerships or unincorporated businesses that would have corporate partners. So in some ways, the fact that sub is liable for the corporate franchise tax rate here is because a corporation has elected to partner with a QHTC in this manner. And so LLP could obviously change its structure, could become incorporated, and then would be able to take advantage of the full amount of the corporate franchise tax rate benefits that are afforded to incorporated QHTCs under the statute. Throughout the trial record, it's quite clear that Accenture made a deliberate determination to remain as an LLP when it restructured, and it did so without consideration of how state tax implications affected that. It is clear that if it wants to get the benefit of the statute, it has a way to do so. It also has the ability to go back to the council. This statute has been revised twice now, and at no point, to my knowledge, has Accenture gone back and said, look, you wanted to encourage business in the district, including for unincorporated QHTCs, but the way that you've done it here is actually hurting us. They could have done that when the QHTC legislation was being amended. They could have also just gone to the council and asked for their own tax abatement, which we see corporations doing and unincorporated businesses doing all of the time. And so I don't think that the mere fact that the consequence of Accenture and Accenture sub structure puts them outside of the ability to take advantage of the corporate franchise tax benefit for incorporated QHTCs requires some sort of gymnastics to rewrite or reread the statute in a way that doesn't accord with its plain language and also is inconsistent to the concerns presented in the legislative history. I do see.
Thank you, Ms. Go ahead, Judge McLeese.
I just have one last question, which is, it's a further component of your opponent's argument is whatever else you think about all of this, it's a basic principle of tax law that if you're essentially treating an entity as a pass-through entity, then you need to pass through the tax benefits that the underlying entity would have to the entity that ultimately, on which the tax is ultimately incident. And the way the district is applying its tax statutes runs up against that. What your opponent argues is kind of a basic principle of taxation. What's your response to that line of argument?
So first, it was not preserved below. In fact, at motion for summary judgment, I think it's 32 footnote 48, the party said they were not at this point raising the question of whether QHTC status should flow up from LLP to sub. They asked for an opportunity to have further briefing on that if the court were to disagree with them on their motion for summary judgment. And the district opposed that and said, no, you had your shot at the summary judgment apple. You don't get to have a second round. So that issue is not before the court because it was not before the court below. But I would also note that on the merits, there is a difference between how factors for apportionment or for apportionment flow up and how statuses flow up. The characteristics of the income at issue would flow up in a pass-through entity. But this is not a characteristic of the LLP's income. It's a characteristic of the LLP itself. So the LLP, by virtue of being a QHTC, gets several benefits. It might not get a franchise tax rate benefit, but it can get property tax abatements, it can get personal property exemptions, and for some years it can get exclusions to sales tax. So those are very important benefits that flow to the LLP that the LLP is allowed to take advantage of. And so that entity characterization cannot flow up because it's separate from the income. And independently, sub itself does not qualify as a QHTC. If we were in a position where sub was itself a QHTC, it might be able to get a benefit on its corporate franchise taxes. However, it doesn't meet the criteria because it doesn't have employees in the district, it doesn't have office space in the district. And so since it is not independently a QHTC, it is not entitled to this benefit. and LLP is the one who can take the benefit. It may be that it can't get a benefit on its corporate franchise taxes, but that's how the council structured the regime.
Thank you, Ms. Ali Khan. Ms.
Thank you.
Lipinski-Galan will give you 2 minutes if you need it. We can't hear you. Are you? I think you're muted.
Is that better?
That is better. Thank you.
The magic pointy finger wasn't hitting the right place. I do apologize. The 2 points that I want to bring up is one, in this court having to do with the mandatory nature of the decision, is that for purposes of timing, I think you need to look at the frame. Frame in this court in Frame clearly said that when the appellant has been affirmatively misled into delaying the filing of a motion of appeal by some action or conduct of the trial court, the appeal will be allowed if the notice of appeal is timely filed after the misleading action has been corrected. Clearly, we have in the timeline and in the facts that once the District of Columbia, Attorney Wood and the then attorneys called the clerk and said, we're waiting, we're out here, we're waiting, what are we going to get? And the clerk called back and by email said, I've talked to the judge, he's decided, no, that was it. Within 30 days of that time period, the appellant then filed the appeal. So they did exactly what the court had instructed in Frame, that as timely filed after the misleading action had been corrected. So the appellant did do that without a doubt. I then have one other argument that the court made about, that the DC has made about the partnership returns. You're right, the entity that is in the District of Columbia, the LP, does get property tax benefits. Remember, and we've always said, it has an office, it has employees, it has a physical presence in the District of Columbia. It has an LLP, but if you look at the federal law, which the DC law is in conformity with, partnerships can do that. They are separate legal entities. If there are benefits that they get them, that's fine. That is all calculated into the income that is then flowed down and pushed down. So if they get a credit for training, they get a credit for property tax, they get a credit against their business license tax, or they have to pay the baseball tax in the District of Columbia, all that is calculated, and then the income and or losses is pushed down to the partnerships. It is well-established federal law and state law that a partnership, everything gets passed down to its partners. All characteristics get passed down. It's not the characteristic of the entity itself, whether or not it gets to have free parking spaces or anything like that. The characteristics that are noted in the Internal Revenue Code are credits, losses, and definitely, and any benefits that is done in the calculation, that net gets pushed down to the partnerships, and they get to take the credits to the same extent that the entity did. They get the losses to the same extent that the entity did. So all we're saying, Your Honors, is if you are going to believe that it's a partnership and it needs to pass it down, then we get those same benefits that the partnership gets as a qualified high-tech credit or certified company, which includes a reduction in the franchise tax rate. So that is just established federal law. The other thing is that the DC says that we didn't argue this in the court below. It was in the initial petition. It is in the brief that was filed and argued in the Superior Court. You're right that we said, if Your Honor is going to go down this road, we want a chance to brief it further. We absolutely did, but it is in the petition, in both the original petition and the amended petition, and was argued at the trial court. So
all right, thank you. Thank you to both
much,
counsel for your arguments. This case is now submitted.
Thank you, Your Honors.
Thank you.
Thank you, counsel.
I don't think we have counsel yet, but for the benefit of anyone still listening, I'll just say that our next case is number 19 CB
0432, Office of Risk Management versus Sheila Jordan.
Okay, Mr. Tuckerman is adjoining.
Looks like he's connecting to audio now. Good morning, counsel. I'll call this case again. Are we ready to proceed, Mr. Green?
Yes, Judge.
All right, it's number 19 CV 0432, Office of Risk Management versus Sheila Jordan. And I believe Ms. Van Zyl is arguing. Good morning.
Good morning, Your Honor. I may please the court, Caroline Van Zyl, on behalf of the Office of Risk Management. I would like to reserve 2 minutes for rebuttal. This public sector workers' compensation appeal presents the question whether a schedule award is available for impairment to the brain or psychological injury. Under the text of the relevant statute, it is not. At the outset, it is important to understand what a schedule award is and what it is not. Schedule awards are not typical wage loss awards. No one here disputes that awards are generally available for injuries to the brain when wages are lost. And schedule awards are not for temporary conditions. Rather, schedule awards are designed to provide injured employees with a sum certain for the permanent loss or loss of use of a particular part or function of the body. Toward that end, the council, borrowing from an existing federal statute, adopted a specific and extensive list of body parts subject to a schedule award and the amount of payment warranted. So 312 weeks compensation for the loss of an arm, 38 weeks compensation for the loss of a great toe, and so on. This list also accounts for the loss or loss of use of organs, but notably, the council specifically excluded the brain from the definition of a compensable organ. The message is clear. A discrete award for impairment of the brain over and above actual wage loss benefits is not permitted. Not only is the statute clear on this score, but ORM, the expert agency overseeing public sector workers' compensation, has issued an opinion here and regulations clarifying that impairments not listed on the schedule are not available for schedule awards. That determination merits deference.
Can I ask you a question? Oops, sorry. Go ahead.
Okay. Just to place this claim in context, can you help me situate it in the workers' compensation scheme procedurally? And what I mean by that is, there was originally a temporary wage loss claim, and then I guess there was a return to work in, looks like maybe September of 2016. And then 8 months go by, and there is then the request for a schedule permanent, a permanent schedule award. What kind of a claim is that procedurally? Is that a motion to reopen the earlier claim? Is it a new initial claim? Is it a motion to modify? What is this second application? What do you understand it to be? Where does it fit in terms of timing and who you raise it to and all that?
Of course, Your Honor. So schedule awards are typically available once temporary benefits have ended and once an employee has reached maximum medical improvement. So the award is available once a pre-existing injury that has been deemed compensable has gotten as good as it's going to get with medical treatment. And so procedurally, what the claimant does and what the claimant did here is files a specific form along with medical documentation requesting a schedule award for a specific body part, here the head/brain. And so procedurally, I would describe it as an outgrowth of the original award or notice of determination as opposed to a completely different proceeding or reopened case.
What statute or regulation, I guess, would you consider such the later application to have been filed pursuant to? Not substantively, but procedurally.
Procedurally, so, I mean, obviously, substantively, the most relevant statute is 623.07.
Understood.
There are regulations that do cover this that were promulgated in 2017. Basically, what the regulations say is that because the statute is silent as to whether this is the sort of determination on which you get a hearing, ORM has interpreted the statute to funnel those sorts of claims through the program, the CRO, and then up through the Superior Court into here as sort of part of the progression. My understanding is that it's part of the progression of the case.
And you're not sure, though, about which statutory subsection authorizes the filing of, under which statutory provisions is this claim processed? What statutory provisions tell you when they need to be filed, when they're timely, when they're not timely, and all that? You're not entirely sure.
So I know that the regulations do cover that, but I don't have at my fingertips if there's a particular statutory hook or if the agency was filling in ambiguities there.
Thank you.
In addition, it bears emphasizing in terms of where the brain fits into these schedule awards that the statute specifically, again, excludes the brain from the definition of an organ. And I would note, as we noted in our brief, that the term organ is only used twice in the relevant sections of the CMPA. Once to define an organ as something that does not include the brain, back, or heart, and then in the schedule. And so here, as a substantive matter, it's very clear that the council intended to exclude the brain from schedule awards.
Do we know the reason for that? Like the exclusion of back, brain, and heart? Is there legislative history on that?
So there's no legislative history in the context of the CMPA. The legislative history there is basically just that we intended to incorporate existing or replicate existing federal law, the FECA. However, there is legislative history as to the FECA. So in that statute, an original draft actually provided for schedule awards for back injuries. There was then testimony at one of, I believe, the Senate hearings where a doctor explained that injuries to the back are both difficult to diagnose and difficult to classify. So schedule awards are designed to essentially predict wage loss based on the loss or loss of use of a specific part of the body. And the testimony was basically that that is hard, if not impossible to do as to the back.
So if somebody, I'm sorry to interrupt, but if somebody had like a severed spine or something and was in a wheelchair, would that fall outside the statute, or would it be, it's like so bad that it would also involve use of arms and legs that do fall within the statute?
That's exactly right. So just to close the loop on the legislative history and then to turn to your question, what happened after that hearing was this definition was inserted that exempted the back, heart, and brain from the definition of organ. So I think it's fair to assume that a similar rationale applied to all of them. What I would say about a severe spine injury like that, and you could say something similar about brain impairments, is the disability radiates, right? So if you had a severed spine, you would expect to see the loss of use of perhaps both legs, which are compensable as consecutive awards. So similarly, the schedule, for example, doesn't include the loss of use of the shoulder, but we often see awards in cases where the shoulder was injured. It's just that the shoulder injury impairs the arm, it radiates, and so that's what you see the award for.
I assume, is it also true that in a scenario like that, there might also be the possibility of getting a wage loss award if it had a wage loss impact?
Absolutely, absolutely. And that is the default in workers' compensation. The default is that you measure compensation by wages lost. So, here, for example, Ms. Jordan was temporarily out of the office for about 6 months, and she received wage loss compensation, temporary wage loss compensation for that time. Schedule awards are quasi exception to that rule. They are still meant to capture predicted wage loss where the injury is severe enough that wage loss can be presumed, but you don't have to show wage loss. And for that reason, sometimes they can both overcompensate or undercompensate for what you might expect to receive based purely on wage loss. But it is
When the claims
different-
examiner first denied this claim, the rationale was that the initial claim was for the chemical burns to the face and that there was no, the basis of the wage loss award was not PTSD. When the CRO upheld the denial of the award, the main rationale appeared to be that the brain is not an organ and there is no schedule award listed in the statute. But my recollection is that the CRO also mentioned again this original rationale. Are you defending that rationale here? Is that a reason for denying a schedule award if it were otherwise warranted?
So we did not take an affirmative appeal on that issue, nor did we brief that issue in our opening brief. So it's not before the court. We put all our eggs, so to speak, in the statutory basket for purposes of this appeal. We do not concede, however, that there was anything incorrect about that argument. We just think that it is incredibly clear that the statute bars compensation under the schedule for a psychological impairment, and therefore you don't need backup or alternative rationales. One other textual wrinkle that I would note is if the court were to, as Ms. Jordan requests, open up the schedule to awards for body parts that are not specifically named or not considered compensable organs, the court would also have to determine how to measure wage loss, because there's simply no relevant text. And so the question would be, do you manage it, do you value these losses based on actual wage loss, based on some proper and equitable consideration in proportion to the total body? There are so many different options for compensating these awards that it is a quintessentially legislative judgment in terms of whether and how to do so. So that is another reason why we would urge the court not to open up the schedule and embrace a sort of atextual non-schedule award for permanent partial disabilities.
There was a theory, I guess, at one point, although I'm not sure it's been pressed in this court, that another way of looking at this injury and this claim was as a whole body injury, and there would be an effort to try to find a place in the schedule or read in a place in the schedule for that. I assume that much of what you said would apply to that alternative way of looking at it, although the provision about organs and all that wouldn't be applicable. Do you think anything distinctive in how to assess that possible way of looking at this kind of a claim, or do you think it really doesn't add any issues that are distinct from the ones we've already been discussing?
I don't know that it does add anything distinct from what we have already discussed. I mean, as you noted, there's not a specific exclusion of the whole body. It's excluded by implication under the expressio unius canon. I would also note that under the AMA, which is sort of the touchstone for these schedule awards, psychological injuries are to be compensated as injuries to the brain or impairments to the brain. The AMA does talk about whole body impairments, but it's been understood, I think, that whole body impairments aren't compensable under the CMPA schedule.
Any other questions? Well, if not, thank you, Ms. Van Zyl. And if you need a few moments, I think you actually have a couple minutes left for rebuttal. We'll return to you. Thank you.
Thank you.
Let's hear from Mr. Tucker.
Good morning.
Good morning.
May it please the court. My name is Charles Tucker Jr., and I'm counsel for the appellee, Ms. Sheila Jordan. Sheila Jordan respectfully asked this court to affirm the Superior Court's decision reversing the agency's denial of her petition for permanent partial disability compensation for three main reasons. One, The agency's decision is arbitrary and not in accordance with the facts. 2, the agency's decision is not in accordance with the law. 3, affirming the agency's decision would effectively serve as a blanket endorsement of unequal protection under the law. Your Honors, we're here today arguing about whether or not public sector employees are entitled to equal protection under the law that governs workers' compensation in the District of Columbia. The permanent partial disability compensation Ms. Jordan has been denied under the CPA is afforded to DC's private sector employees under the Workers' Compensation Act and to DC's federal employees under the Federal Employees Compensation Act. Although it has been long established that mental and emotional injuries are compensable under workers' compensation law, the agency has interpreted the statute to require that PTSD be considered a brain injury for which compensation is barred. This interpretation upon which the agency bases this decision is arbitrary and unreasonable, as the court did find. For this reason, the court owes the decision no deference and must, in the interest of justice, review the statutory interpretation de novo. Brings me to my first point, Your Honors, which is that the agency's decision is arbitrary because the factual findings upon which the decision is established are not supported by substantial evidence. This court has recognized what substantial evidence is, and it's more than a scintilla of evidence. Here, the record supports 2 main facts. 1, Ms. Jordan filed a Form 12 making a claim for permanent partial disability compensation, or specifically PTSD, not for injury to her brain. Secondly, that the agency approved compensation for Ms. Jordan's PTSD. Getting more precisely to my first point, Section 3, subsection B of Form 12 lists Ms. Jordan's diagnosis or nature of disease or injury as post-traumatic stress disorder. Section 3, subsection D of Form 12 specifically describes findings and relevant diagnostic test results as avoidance of fear and anxiety. Subsection 3, E of the Form 12 lists the healthcare provider's specialty as a psychiatrist. Now, Your Honors, I'm not a medical doctor here trying to break things down for you this morning, nor do I claim to be. But clearly, those facts illustrate that Ms. Jordan was being treated for a PTSD claim, a injury, or a issue dealing with physical, emotional impairment. The entirety of the record submitted in support of the PTSD claim specifies the condition and injury as specifically PTSD. It is unreasonable then for the agency to make a factual finding that Ms. Jordan sought PPD for a brain injury.
Well, counsel, let's
say
that that's correct.
Yes.
How does that advance your ultimate argument that your client is entitled under the statutory schedules to receive this type of benefit? Let's assume that rather than putting it in the cubbyhole of brain, or at one point there was a possible cubbyhole of whole body, there's been suggestion of head, so there have been other possible ways of looking at it. But let's say your client is understood to have been trying to get a scheduled award for PTSD. How do you fit that into the statutory language relating to when you can get scheduled awards?
Well, specifically, Your Honor, I'd point you to Section 1623. The agency's statutory interpretation is not holistic, okay? Because it focuses exclusively on Section 1623.07, subsection C of the CMPA. Despite the fact that this portion of the statute only enumerates a compensation schedule, the agency has interpreted that to mandate a denial of PPD compensation for any unlisted condition. This interpretation is erroneous, as it would bar PPD compensation for any and all mental or emotional illness. The agency looks beyond the scope of this section only to find an irrelevant exclusion for brain injury for which no PPD compensation has been requested in this case. It is
Counsel, assume that you are correct, and or that at least we're walking down your chain of reasoning, and we say, okay, it may well be true that there should be compensation under some sort of scheduled compensation for unlisted conditions or organs or body parts or the like. What provisions would determine the amount of that compensation? How much? Let's say your client, we take it as a PTSD claim, and a court determines, or the agency determines, your client has PTSD, and assume for a moment, even though it's not listed, it is potentially compensable. Then the question would be, how much compensation would your client get? How would an agency and a review in court figure out how much compensation would be available as a scheduled award for PTSD if that were otherwise appropriate?
Great question, Judge McAleese. Judge, I would direct the agency then to, as it's in its own brief say, they looked for the federal statute for guidance. The federal guideline under the FCA, they provide compensation for PTSD. Clearly,
well, counsel, do they? I mean, I'm not sure the issue in this case is quite whether these awards are compensable at all, because I think your opponent has acknowledged. I mean, your opponent has acknowledged that if they cause wage loss, that they might well be compensable under other provisions of this workers' compensation system. The issue is whether they are compensable as scheduled awards. And are you saying that your understanding is that under the FECA, as it applies to federal employees, they can receive scheduled awards for PTSD?
Okay. What I am saying, Your Honor, it is specifically noted that subsection C of the federal statute supplies a compensation schedule with 22 entries that are identical to the 22 entries of the CMPA. Further noted on page 20 of opposing counsel's brief is that the U.S. Department of Labor has made clear that brain impairments are not compensable with schedule awards. Despite this interpretation, the Department of Labor has consistently interpreted the FECA to provide compensation for mental, and emotional injuries.
For scheduled awards?
Yes, specifically PTSD arising from a physical injury, which we do have in this case. And I'd like to point the court to—
So counsel, let me make sure I understand. Is your point that if there is an injury to a part of the body that is listed, and one of the symptoms of that injury, or one of the consequences of that injury, is PTSD, that's taken into account in figuring out whether there is, and if so, the extent of a partial disability to a scheduled body part? Or are you suggesting that under the federal system, a federal employee can come in and say, I had a workplace injury, I'm not suffering any wage loss, I don't have a body part other than the brain that I can point to as having been injured, but my claim is that I would like to get a scheduled award, a partial scheduled award that focuses exclusively on the fact that I have a PTSD diagnosis. Are you saying that you understand the federal statute and the cases, administrative or judicial cases addressing the federal statute, to provide for scheduled awards along that line of thinking?
Your Honor, what I am asking is how the agency, the government, would manufacture such an award is left to them to figure out. However, what I am saying, in this instance, on these facts, we have an injury from a work-related, we have a diagnosis from a work-related injury that should be compensable. And in fact, from the record, it was. The agency both paid for the loss of wages, they paid for the treatment, the medical treatment for the diagnoses, and in fact paid for supplement requests for treatment, surely the agency has the ability to figure out what kind of compensation or how the compensation schedule should look like. But to use a compensation schedule and say, well, it's not specifically listed, this automatically bars your claim, is unjust, because the work-related injury that brings us here today, and it's important to make the actual distinction of what we're talking about. Counsel would like you to believe that we're talking about a brain injury. That misnomer is a deficient fact, because it points to deficiency in their form. The record is clear that the Form 12 gives no ability for an individual to make any recommendations or relations as to functions of a body. In this instance, the Form 12 forces someone to identify a body part, of which point the psychologist or treating individual, the doctor in this instance, was forced to fill out and put brain. However, the diagnosis was consistent with PTSD. The medical documents submitted in a record are consistent with PTSD, and the treatment by their own doctors supported in the record that at all relevant times she was being treated for a PTSD condition. The FECA has an identical comp schedule, identical exclusions for brain injuries, yet it consistently awards PPD for PTSD. I don't know how it's calculated, Your Honor, and I will not attempt to make such an assumption at this time. However, the agency determined such.
And did you, when you say that about what happens under the federal system, are you saying PPD awards that are under the schedule? They're not wage loss awards, they are scheduled awards. And have you pointed us to administrative or judicial authorities that reflect what you're saying is the case with respect to what happens with respect to claims like this under the FECA? Because your opponent cites to some authority under the FECA that it argues supports the idea that the administrative and judicial authorities that have been considering this question under the FECA, and this question somewhat more broadly, which is, can you get a scheduled award for something that's not listed and doesn't fall within the catch-all provision? Your opponent argues that the authorities actually go the other way, and they say, if you're not on the schedule and can't fit within the catch-all, as you know, back and brain claims can't, then you cannot get a scheduled award. But you're saying that your understanding is that that's not the case, and that there's authority for giving such awards?
Your Honor, I'd point the court to Spinelli versus the director of the Central Intelligence Agency, which is a 2006 case. And here, this individual was, I believe, shot and received treatment years later after his initial claim. The secretary determined that Spinelli's PTSD claim was covered. And in fact, the facts relate that he didn't even apply. In reviewing his case, the Secretary of Labor determined that he was entitled to an award for PTSD and made the claim for him. In this
under the schedule?
Yes, Your Honor. And found the ability to do so under the FECA. And it was a PTSD claim years later. I mean, it was my understanding from the facts, it was several years later.
Do you have a citation for us? I don't recall that case from your brief.
It's not in my brief, Your Honor. I brought it in case such a question arises out of my review of the opposing party's brief, and knowing that argument, I anticipated their argument, so I brought an actual case that actually.
Can you give
related-
us the citation, please?
Yes, Your Honor. It's again, it's Gianpaolo Spinelli versus Director of the Central Intelligence Agency from the United States District Court for the District of Columbia. It's a 2006 case. That's
If
the
you
only-
don't have the citation, perhaps you can submit a Rule 28K letter and send it to us, please.
I can, Your Honor.
Thank you. Your time is up. Thank you for your argument. Ms. Van Zyl.
Thank you, Your Honor. A few points, starting with the last point that my friend was addressing. The ECAB is the final adjudicatory agency that determines workers' compensation awards under the FECA. And we have cited a number of ECAB decisions that stand for the proposition, one, not only is the brain not compensable, and not only are psychological injuries not compensable under the FECA, after which the CMPA was modeled, but there is no such thing as an extra schedule award. The schedule awards are limited to the body parts delineated in the text of the statute. And in our brief, we quote In re Lawrence Fulton, which was a 2002 ECAB case. And we have reviewed the cases that have addressed this issue since, and that remains good law in the ECAB. If the DDC has decided something else, first of all, it would be very surprising to me if it were dealing with a schedule award. And second of all, I'm not sure what the authority would be to adjudicate workers' compensation schedule awards, since federal law is very clear that the ECAB has the final say and is unreviewable even through mandamus on these issues. Second, in terms of whether PTSD is properly viewed as a brain impairment, the Form 12 that was submitted by Ms. Jordan, which is in the appendix, terms this as a brain/head injury. So that was her representation. That is in accord with the AMA guides, which are the touchstone for these determinations under the relevant regulations. And so to now say that PTSD is something other than a brain or head impairment, I think is foreclosed both by the Form 12 and by the briefing that has since occurred in this case. And in terms of this idea that somehow Ms. Jordan is being treated unequally because she has a psychological impairment, either because the Workers' Compensation Act might compensate something like this, or because in circumstances where wage loss occurred, she would be entitled to compensation. That just is not true either as a matter of fact or as a matter of law. Under the WCA, if you want to get a non-schedule award, you have to show wage loss. And here, the issue for Ms. Jordan is that she has not shown wage loss other than the first 6 months when she was out of work. There's been no continuing wage loss. And I would note that to the extent that there are differences between the public sector and private sector statutes, those are presumably intentional and they adhere in the text of the statute. If Ms. Jordan wanted to challenge that as being contrary to equal protection or something like that, she would have had the opportunity to do so in her briefing here and below. She did not. And for those reasons, if the court has no further questions, we would ask that the judgment of the Superior Court be reversed. Thank you.
You're on mute, Judge Thompson.
Oh, thank you very much. I'll repeat my thanks. Thank you to both counsel. The case is submitted. We'll ask Mr. Green to work his magic and bring in the next counsel for our third case. It's actually consolidated cases. There are numbers 18 CV 0945 and 19 CV 0155, Nita B. Archie versus US Bank NA as trustee for the RMAC Trust Series 2016-CTT. The same name in both cases. Good morning, counsel. I guess it's still morning. It is.
Morning, Your Honor.
Morning.
And Mr. Knott, I believe,
Yes,
is
Your Honor.
counsel for our appellant.
Yes, Your Honor.
You
Jason
may
Knott.
proceed when you're ready.
Thank you, Your Honor. May it please the court. Jason Knott for the appellant, Nita Archie. I'd like to reserve 3 minutes for rebuttal. The Superior Court erred when it granted summary judgment to PennyMac, now US Bank, in this appeal, and rejected Ms. Archie's numerous fact-bound defenses. It's important to remember, in setting the stage for this appeal, that US Bank is not a holder in due course. Thus, it is subject to all defenses that Ms. Archie would have had against the original lender, Premier, if Premier had brought an action to enforce this loan.
Why is US Bank not a holder in due course?
PennyMac admitted below that it was not a holder in due course because it took the loan with notice of Ms. Archie's default. And that admission is binding on US Bank here. When US Bank was substituted after the judgment, it admitted that the substitution didn't change anything about the underlying facts. So that was admitted below. The first defense I'd like to turn to is the defense of unconscionability, both under the CPPA and under common law. And under the CPPA specifically, it's prohibited conduct to make a loan to a consumer with knowledge that they have no reasonable probability of repaying it. And
Can I
that's
ask you
exactly
about an aspect of that? I understand the CPPA as a counterclaim. That's very straightforward. I don't gather that your opponents have conceded that because they're not holders in due course, they are subject to any counterclaim that might have existed against their predecessors in interest. Do you understand them to have conceded that with respect to counterclaims, they stand in the shoes of their predecessors in interest?
Judge McLeese, I'd like to address two aspects of the counterclaim. We did assert a defense in recoupment under the CPPA, as well as a counterclaim against PennyMac for its efforts to enforce an unreasonable loan. Those were two separate issues. I don't understand US Bank to have conceded that Ms. Archie has either a valid claim in recoupment or a valid counterclaim, but for purposes
Okay, thank you. The second aspect of my question is, to the extent you are relying on, let's say, for example, CPPA unconscionability as a defense rather than as a counterclaim, is there case law or statutory language in the CPPA that explains how it might operate as a defense in a foreclosure action rather than as a source of counterclaims or other affirmative relief?
I'd say that the statute expressly addresses a successor or a sign of a merchant as someone who is liable under the CPPA. That's in section 3901A5.
Right, and that would be as a claim. I mean, you're liable on a claim. So I'm not sure that's directly responsive to the question of the extent to which and the source of the extent to which the CPPA operates, not just as a basis for counterclaims and affirmative relief, but also as a defense to a foreclosure.
Well, in this aspect, we are asserting the CPPA as a claim in recoupment. So you can call it a defense, you can call it a claim in recoupment, but it is a way of offsetting the claim that PennyMac, now US Bank, is asserting against Ms. Archie. On this,
how does it operate as a claim in? I'm sorry to get bogged down on this, but I'm not sure I understand how this works. How does it operate as a claim in recoupment? So let's say that there is an originally fraudulent loan, and then it gets passed on down through other banks that, assume for a moment, those other banks don't know anything about what happened thereafter, but they may or may not be holders in due course, but they've done nothing wrong with respect to the original fraudulent transaction. They just purchased a loan. And are you saying that the way the CPPA works is that, I mean, what do you recoup against whom in virtue of the fraudulent, presumably fraudulent or unconscionable here, more precisely for this claim, unconscionable original loan? How does it operate in recoupment, and against whom? Is there sort of a strict liability if the original loan is invalid and you are on the supply side thereafter, at least if as a purchaser of the loan, that the unconscionability is a defense that allows you to recoup something, but I'm not sure what?
So after a trial, a jury could have awarded damages to Miss Archie, for example, and under the CPPA, those damages could be trebled. There could have been punitive damages imposed.
But that requires first that there be a claim, an affirmative claim established under the CPPA. Is that correct? It's not as though it's a defense independent of, first you can establish a CPPA counterclaim, and then you can use the award there in recoupment as a defense, or to decrease the amount of liability that would otherwise have been established in the context of the foreclosure. Is that how it operates in your view?
Yeah, what it is that allows Miss Archie to assert this claim in response to the foreclosure is that both the CPPA and the UCC allow a consumer to assert as a recoupment claim, claim having to do with the wrongful origination. And I'd point also to the provision in the UCC, which is 28:3-305A3, that makes this crystal clear that when an assignee is not a holder in due course, as is the case with US Bank here, then the payee can assert claims against the originator that it would have had against that party. And so the UCC, in addition to the CPPA, would permit Miss Archie to assert these claims. Now, had US Bank never acquired this loan, could she have sued US Bank under the CPPA? No, but that doesn't address the question of whether once US Bank brings an action against her, standing in the shoes of Premier, can she then assert as a recoupment claim, a claim having to do with the wrongful origination of the loan that PennyMac, now US Bank, is seeking to enforce. And I would also note that PennyMac and now US Bank never contended that Miss Archie couldn't assert, for example, unconscionability defenses at common law as a defense and as a recoupment defense, or fraud, for example. And so I think it would be entirely inconsistent with the statutory objectives that the DC Council had to hold that only when the CPPA is at issue, you cannot assert, even as a recoupment claim or a recoupment defense, a CPPA claim. I think that would run afoul of the DC Council's desire to prohibit these kinds of transactions.
You keep talking about the recoupment and not focusing so much on counterclaims. Are you saying that you think that Ms. Archie is not entitled to pursue, or was not entitled to pursue, PennyMac and now US Bank on counterclaims, but can only use these CPPA provisions as essentially defenses, recoupment bases?
Judge Thompson, I want to be clear. I am not taking the position that Ms. Archie could not assert a counterclaim against PennyMac. She did assert such a claim because the CPPA provides that it's not just unconscionable to make an unreasonable transaction, it's also unconscionable to attempt to enforce it. And that's what PennyMac did, and that's what her claim was premised on. But I think that it's a very, if you look at the recoupment defense, I think that's somewhat of an easier question to resolve than the claim of against PennyMac as to enforcing an unreasonable transaction.
One of the things you say in your brief is that one possible remedy for Ms. Archie might be a life estate in her home. I was scratching my head a little bit about how you got there as opposed to some other remedy, because as you say, under the CPPA, one of the remedies that's available is treble damages, for example. And I got to thinking about where that would leave Ms. Archie if she were to prevail on a claim for treble damages. How did you get to the suggestion about a life estate?
Judge Thompson, the suggestion of a life estate was more addressed to the court's exercise of its equitable powers. Foreclosure is an equitable action. And in that context, we believe that the court would have the power to craft an appropriate remedy given the numerous circumstances presented in this case, both as to the wrongful origination of this transaction, as well as Ms. Archie's changed circumstances during the past 13 years since this loan was originated. So I think that would be something that would be within the court's discretion on remand, but of course there's a lot that would have to happen before we would get to that point.
Well, that was going to be my next question. You're not suggesting that the record is developed in such a way that this court could look to that as a remedy to impose. We would need a remand for that.
There would have to be a remand. And again, this is leaving aside the statute of limitations issue on which we believe you could grant judgment for Ms. Archie. But if the court disagrees with that, then I think there would have to be a remand for a trial for a jury to first address the numerous disputed fact issues because the CPPA is a claim that is subject to a jury trial right. And I would point the court to the Williams versus First Government case from the DC Circuit, which I think provides a good explanation of how this would play out in practice. In that case, Mr. Williams had asserted both a claim under the CPPA and a claim of common law unconscionability. And there was a jury trial at which the jury found that the lender had violated the CPPA. And then subsequent to that, the court addressed the issue of common law unconscionability. So the jury's findings were allowed to take primacy there.
And in this case, what do you think are the major issues for a jury?
So I think the major issues are as follows. A reasonable jury could have found that Premier violated the CPPA, certainly by lying about Ms. Archie's income to qualify her for the loan. And I'd like to direct the court to a couple pieces of the record that make that, in my view, crystal clear. At page 799 of the joint appendix, you'll see the last loan application, which is dated as of the date of closing, which in itself is highly unusual. And you'll see that it reports Ms. Archie's income as $12,187. And if you look at page 871 of the joint appendix, you see the underwriting requirements that Citi gave to Premier, because the way that this transaction operated was Citi was going to buy this loan immediately after it was originated. And you see that Citi told Premier that Ms. Archie needed $12,187 of monthly income to qualify for this loan. And I think what that shows is that Premier obviously knew exactly the income that Ms. Archie needed to qualify for this loan. And that's exactly what they put in that last loan application. And that, in my mind, would have been certainly more than sufficient for a reasonable jury to find that Premier had knowledge that there was no reasonable probability of payment in full by Ms. Archie, that Premier, in fact, misrepresented Ms. Archie's income. And I'd also point the court to the testimony of the only other person who was involved in all of this who testified, who was Rob Jackson. He participated before the closing. And I would really recommend looking at his testimony carefully, because you see, when I asked him about these loan applications, he interrupted me. And this is at page 683 of the joint appendix. And he said that he couldn't remember his own signature and that he has changed his signature since then and it looks different. He also, though, admitted that the loan file contained crazy stuff that should never happen. And in particular, he was referring to the changing income on the loan applications. The other documentation in the record, the fake pay stubs in the W-2 didn't add up even to the income that Premier was representing. So a reasonable jury could easily have concluded that Premier violated the CPPA. And as the DC Circuit said in Williams, that would have been highly persuasive as to a finding of common law unconscionability as well.
I ask you again, I'm sorry to circle back around to this in a way, but when your answer says a reasonable jury could have found that Premier violated the CPPA, I do get back to being uncertain about what that means with respect to the liability on a CPPA counterclaim of Premier's successors in interest. And I understand your point that it's unlawful under the CPPA for in certain circumstances to be unforcing and unreasonable or prohibited agreement, leaving aside in addition to originating one. But if you're a bank and you lend me some money in a fraudulent transaction, and then you sell that interest on to someone else who was not complicit in your wrongdoing, may or may not be a holder in course for purposes of other doctrines, but just as a matter of the CPPA, are you saying that anybody who buys that loan and then tries to enforce it, assuming, let's say, they're not a holder in due course, you're saying that if they try to foreclose on the loan, if there's been a default, that they are liable under the CPPA, meaning that they can, have to pay statutory civil penalties and treble damages and all of that. Is that how I understand the way you think CPPA counterclaims work, which would then be a predicate for CPPA recoupment?
So I don't think you have to accept that proposition to find for us. I think you'd have to inform that decision by looking at the statutory language of the CPPA as well as the UCC, which I think is informative here. The CPPA does provide that a proper respondent, is a successor or a sign of a merchant. So I think that language—
Although I thought there was language, I don't have that statutory provision in front of me, I thought there was language in that definition about someone who is liable under principles of law. I'm paraphrasing, but—
That's correct.
So then you'd have to figure out under that statutory language, at least, whether there was some principle of liability that would make the subsequent purchasers liable in some way, vicariously, I guess, for the conduct of the loan originator.
What it says is that it applies to successors or assigns as well as others legally responsible. In here, the UCC, I think, makes crystal clear that as an assign, U.S. Bank, which is not a holder in due course, and that does make a difference under the UCC, right? And the UCC, I think, addresses your concern about perhaps imposing outsized liability on banks that have no awareness of what happened.
Yeah, my question is all about the CPPA and the counterclaims and liabilities that it imposes. I think the structure of the UCC is quite different, both in terms of the consequences of a determination and in terms of the statutory language at issue. So my question is really more, I'm having trouble working through the CPPA counterclaims and how they would be available as against subsequent holders of the note as a basis for counterclaims that impose quite significant affirmative consequences, not just sort of a defense to someone who's trying, or a set off to somebody who's trying to enforce a note. So my question is really all about the CPPA. These questions are all about the CPPA, not so much the UCC recoupment theories.
Sure. But I think under the UCC, Ms. Archie's CPPA theory would be available as a recoupment defense. But I want to speak specifically to your question, which is that the statutory language of the CPPA says that a proper respondent is a merchant, a successor, or a sign of a merchant, or another party legally responsible. And as an assign of a merchant, I think U.S. Bank would be properly subjected to a counterclaim based on that language. But again, you don't have to reach that issue to permit Ms. Archie to assert a recoupment defense that she would have had against Premier, given that U.S. Bank is not a holder in due course, that under the UCC, all the claims that she would have had available in recoupment against Premier are available to her. And I do not see a reason under the CPPA to carve violations of that statute specifically out of the availability of those defenses.
You were answering my question about the major factual issues for a remand, and you got through number one. What are the others?
So the others, certainly the testimony of Rob Jackson. I think it was also strongly disputed in the record As to Miss Archie's knowledge and agency in all of this, I don't think that affects the CPPA question, because as this court recognized in Modern Management versus Wilson, and as Judge Bates recognized in Hughes v. Abel, what you might call victim complicity doesn't mean that the person doesn't have a CPPA claim. There was, of course, a strong dispute that Miss Archie had knowledge that Premier was misrepresenting her income, and that was an issue that the jury would have had to resolve. The court ruled on summary judgment that she couldn't establish any of these defenses because she'd had prior transactions. But again, if that was the case, you wouldn't have had a plaintiff prevail in Modern Management. In DeBerry, where this court ruled that the CPPA did apply to transactions just like this one, the plaintiff had been involved in 4 refinancings, and the court never suggested that the latter 3 would be, of course, exonerated for the lender. And the court didn't hear from Miss Archie at all, so it didn't consider all of the circumstances, which you would certainly have to do before ruling on common law unconscionability. It didn't address that, perhaps the fact that she was involved in these prior transactions shows that she was easily susceptible to being duped by a scam like this, that, excuse me, that she suffered from disabling mental and physical conditions. That's also present in the record. And that Premier made representations to her about the effect of this transaction.
Is your argument that that there's both substantive and procedural unconscionability here? Or are you arguing that this is particularly egregious procedural unconscionability?
Our argument is both, that we satisfy both prongs. I think in this case, either would be sufficient. There are circumstances where if you satisfy one factor and it's egregious enough, that can justify an unconscionability finding. But here there was procedural flaws leading to this transaction. And then there was also the flaw of the substance of the transaction as a whole, which is that Ms. Archie was receiving a loan that was increasing her personal obligation that she couldn't afford, and that Premier knew it, and that they lied about it in order to get her that loan.
And does that fall within the case laws understanding what substantive unconscionability is, or is it more fraud?
I think it could satisfy fraud, but I think it also falls within what certainly I'd point to Williams versus First Government, where the court recognized that making someone a loan that they can't afford would be highly probative of common law unconscionability. And I'd note that also that PennyMac's own expert testified that it would be improper to make someone a loan in that context. And she's not a legal expert, but she did say that in her view, that would be unconscionable. So I think the case law does strongly support that making someone a loan with knowledge that they cannot afford it and that they have no reasonable probability of repaying it is unconscionable conduct.
Can I ask you, one way of looking at this transaction on the question of whether it's unconscionable, maybe more on the substantive side of what seems to me a somewhat blurry distinction, is you could kind of think of transactions like this as sort of a reverse mortgage, where somebody has equity in a house and they don't really have income, and they can get income out of their equity. So that's a form of transaction that is not intrinsically impermissible or unreasonable, as I understand it. People can sort of sell their equity for current income.
That is true. It's not as though all reverse mortgages are unconscionable, but if the lender knows that the person cannot afford it and has no reasonable probability of repaying it, then I think it would be unconscionable to get that person into the transaction. And again,
well, I guess I'm not sure. I mean, a reverse mortgage isn't something you really have to repay, right? It's the idea is you sort of have your equity and you reverse mortgage it. At the end of it, the other person has the house and you got, or whatever the property is, and you got the income in the interval. So it's ability to repay. If you're thinking of it as a reverse mortgage, if its terms aren't substantively unfair, or ability to repay doesn't really come into the equation.
Yeah, but that's not what this transaction was. Ms. Archie was obligated to repay this loan at risk of losing her house. And so Premier knew that and made her this loan anyway. and effectively ensured that she would no longer be able to retain her home in exchange for a healthy closing fee and then a purchase of the loan from Citi.
Mr. Knott, thank you. We will give you a couple of minutes for rebuttal if you need them. Let's hear from Mr. Smith.
Good morning, Your Honors.
Good morning.
Let me just pick up right where we were talking about unconscionability, substantive and procedural, and the nature of this transaction. One of the things in the case law that they talk about with unconscionability is the effect of the loan. And that really goes to why this loan happened. Again, this was the third loan Ms. Archie took out in 3 years against this property, where she had no mortgage on the property at all, no deed of trust when she took title to it. She'd already taken a lot of money out of the property. And if you look at her own affidavit on page 639 of the appendix, where she says, well, I had to work with these people on the foreclosure rescue program because she couldn't afford the loan that she was in. And so the effect of this loan, whether she could pay it back or not under its own terms based on the income she wound up having over the last 12 years, is that she wound up staying in the property for 12 years and paying only a small piece of the cash that she received from the loan back as payments for a few months.
I thought there was a factual dispute about the extent to which, or there's a claim that there was a factual dispute about the extent to which she actually received the proceeds of the loans.
I think that, yeah, it's unclear what she was saying exactly about that issue, but it is clear that she only made a few payments. I think it was about 8 payments. And according to her, she didn't have income. So I think it's a pretty fair inference that the money came from the cash that she received from the transaction. But in any case, it was less than the cash that was put out by the lender that ever came back on this loan. So she's paid nothing from her Social Security, from anything else on this loan ever. And this was, when you talk about equity here and what the equitable result is, and this was something that Judge Jackson said below, she's paid nothing on this for a decade and more. And in a time when she says she has little to no income, just the Social Security.
I mean, I think her perspective is that it really isn't that unfair that she paid nothing on it. She owned the house free and clear. Someone, gave her a loan that she didn't need, that she couldn't afford, and she ended up paying nothing on it. Her, her view is, what's the inequity in that? That's as it should be from her perspective.
That's maybe a rational perspective if this had been the first loan. Remember, the vast majority of the money from this loan went to pay off her prior loan, over $300,000 that she was in debt at that point. And the reason I started by mentioning that section of her affidavit talking about foreclosure rescue program she wanted to participate in, the reason she got this loan is because she was going to run out of money on that loan and lose the property 13 years ago. So that's why we are where we are now in terms of the equity here. And in terms of unconscionability and the substance of the loan, the substantive terms of the loan are clearly proper and reasonable, and were at the time for a person of her, of her creditworthiness. And the form of the loan, standard federal Fannie Mae, Freddie Mac form loan document. So there's no problem there, and the interest rate is well within what the law allowed. It was an adjustable rate, and over the last 10 years, it's gone way down, actually, lower than even what she would have wanted. But she never reached the point of actually paying on the lower terms. So I don't see any substantive unconscionability here in terms of the loan. And then when we talk about Mr. Knott, has made a lot of what the process was in terms of the loan being originated and her income. And he always characterizes this as what Premier says. But at the end of the day, she signed the loan application. It's her obligation under law to review that and make sure it's proper and to not sign it if it's false. But her position throughout this has been that she didn't read anything. She didn't ask any questions to anybody, essentially ever, about the terms and what she was doing. And, she has a responsibility to do that, or to at least ask about what's going on.
So are you saying that's a complete...
Do you disagree with Mr. Knott in his interpretation of the CPPA and the provision about successors and interest being subject to the same claims as Premier would be?
Yes, we disagree with that. And we don't think that PennyMac or U.S. Bank is a merchant as defined within the Act. And the subsequent case law on that, including some of the cases we cited in our brief, talk about having to continue to be involved in making credit available to a person. For example, the Osinu-Bepi Allow case talks about that. And you know, my clients were completely passive here in terms of taking this assignment and don't bear the same. We're not merchants in relation to her, merchants in general, with regard to this credit transaction. All the credit came from Premier 13 years ago. So we don't see them as merchants, and that was the holding below.
Is that consistent, you think, with the DeBerry interpretation?
Well, DeBerry was the same company, I believe. I don't think there was a transfer there. If I recall, it was the same lender. So I think DeBerry, the core holding there is that the act applies to deeds of trust and mortgage transactions at all. And we don't dispute.
Well, there was a lot of discussion about the provision using the word sales and leases, and how a real estate credit transaction was not that, but the court interpreted the term broadly. And it would seem that if real estate financing transactions could be deemed sales or leases, then those participating could be deemed merchants. What's your response to that?
Well, our view is that you have to continue to act in a way that you're extending something to the person, that you're doing something further, like in a home equity line, some kind of continuing relationship, which is not the nature here. The only credit transaction was the one in 2007. So,
well, don't you had your bank and predecessors had a relationship with her in the sense that she was contractually obliged to make payments to you under agreements that you purchased. Is that right?
Through the servicing, right? Yes, we did have to pay.
And so is it your view as far as the CPPA goes, that if, let's say in this kind of a setting, there's a completely fraudulent mortgage, it's completely unacceptable. You know, it's the result of substantive and procedural unconscionability and fraud. And it would not be, the person who originated is certainly liable under the CPPA. And then someone comes along and purchases that, the note that was created through that process, let's say knowing, how fraudulent the transaction was, and then goes and attempts to enforce it. Now, maybe there would be common law defenses that would preclude enforcement, but just in terms of whether that's a violation of the CPPA, if you, purchase the note knowing that it's completely fraudulent and then you try to enforce it, you're saying not a violation of the CPPA because you're not a merchant unless you do something more than just purchase and try to enforce the plainly and known by you to be fraudulent note.
Well, the hypothetical says that you know that the loan is in fact fraudulent. And I think that makes it different from here, certainly.
Well, the reason I'm asking though is your view was definitionally people who purchase such notes, if all they do is purchase the note and they're not somehow more involved than enforcing the note and maybe accepting payments under the note if any are made, are just definitionally outside the scope of the CPPA. I thought that was your argument, and I was trying to see whether that argument flies.
I think that that's a reasonable way to read the subsequent case law on that. But I'm not sure you have to actually reach that question on this appeal, given that the loan itself, especially on the CPP side, which talks about the terms and provisions, the loan terms themselves are fair and reasonable. The real argument on the other side has to do with the procedural side. And I don't think you get there on the CPPA, even if you might be able to talk about that on common law and conscionability. Although again, we don't think that you should.
Well, how can that be right if one of the provisions that define what makes a loan an agreement unconscionable under the CPPA is the inability of one of the parties to the transaction to make a payment? That's one of the, that's in R5 or whichever it is. It's one of the definitional provisions about how you figure out unconscionability. So I'm not quite sure I follow the argument that under the CPPA unconscionability can only be a function of the sort of objective terms of the agreement without regard to the situation of the parties in terms of their abilities to perform under the agreement.
Okay, I mean, I think that's fair, but the point I was making is that the statute is really focused on the terms and provisions more than the process by which the loan comes to be made. And here, I don't think you can say that there was, certainly the later companies that were involved here, PennyMac and the bank, had any inclination that she never could have paid. I mean, objectively looking at the documents they would have received, the loan documents, you know, those indicate that she did have the income to pay. Now, the contention is that that's fraudulent, but they really don't have any way of knowing that. And at the time that the current party to this case, US Bank, took its assignment in March of 2018, the case had been dismissed. It was later revived, you know, based on a motion for reconsideration in August, but that wasn't even a live issue at that point. So,
well, your current client had to have taken it with knowledge that although it was dismissed, future litigation, including appeal or post, you know, subsequent rulings could change that. So I don't know that, or to the extent you're suggesting your client had some kind of a reliance interest in the case being closed, that seems like a tough position to take.
well, I'm just laying out the situation here in terms of my client knowing that there was some sort of fraudulent loan. That was certainly not clear at all. They're not in the position of your hypothetical, which says that you know the loan was fraudulent. Moving on to the discussion of, there was a discussion earlier about the life estate. I think that derives from a case from New York that the other side cited. And in that case, that was a very unusual case where, in fact, the plaintiff bank in that case had essentially admitted that they had defrauded the person. And at the point where that decision was made, they had actually offered the person a life estate. And the judge essentially said, okay, we'll make that part of the remedy here. But it wasn't a situation where the court imposed the life estate out of nothing as a remedy. That's not a normal remedy that would be crafted, I think. So,
The CPPA, though, does give the court the ability to fashion an equitable remedy beyond the remedies listed in the statute.
that is true. The CPPA gives very broad power to craft remedies.
Right. Mr. Knott actually said a couple of times that we didn't really need to focus on the UCC on the CPPA, because the UCC would subject your client to the same defenses of Ms. Archie. Do you have a response to that?
Yes, I think the UCC has essentially nothing to do with this case. This is an in rem foreclosure action. We've been very clear about that below and in our brief here. And if you look at the complaint, there's no claim for a personal judgment against Ms. Archie for any deficiency. This is just an in rem action. So the relevant issue here is the deed of trust. And this is not a note enforcement action. And of course, this comes up a lot in the statute of limitations discussion. But this is not an action on the note, it's an action on the deed of trust. Now, the note is the underlying.
I just want to make sure I understand your response to Judge Thompson. Are you saying that because of the form of this action as a foreclosure action, that the UCC provisions relating to recoupment are not, as a matter of law, not applicable because of the form of this action? Is that the point you're making now?
I think that's correct. But
was that point in your brief?
I don't think it was. It was not in our brief, but we focused on the in rem more on the issue of statute of limitations.
Right.
And you know, the important, and really all this discussion about the UCC and what Massachusetts court said about the UCC and a note action, and we don't think any of that stuff plays into the statute of limitations issue, which is covered by statute in the district with regard to recovery of land, the 15-year statute of limitations, which we think is the correct answer here. But even if you get into the note or the deed of trust, then they're both sealed instruments, and that's not in dispute. We have a 12-year statute of limitations. So we think that that's, this action is clearly timely under any of those theories. And all the discussion of the UCC is really not the way to frame the issue here. And then in terms of what the disputed issues are going forward, again, I don't think there's a lot of dispute about the creation of the loan, because at the end of the day, Ms. Archie didn't review any of this information. She didn't read any of these things. So we don't really see it as material to the ultimate resolution of the case, how that came about.
Well, the trial court in granting summary judgment on, let's say, common law unconscionability and on fraud, seemed to put a lot of emphasis on the fact that Ms. Archie had been a participant in an earlier mortgage transaction, as though that was just, in light of that, no reasonable fact finder could find the transaction here unconscionable or fraudulent. Ms. Archie's argument is that she was operating within, under mental and physical disabilities, and that in the first, she's the victim of a first fraud, and then to say, I'm granting summary judgment because you were defrauded once before is not a reasonable way of assessing what reasonable fact finders could do. What's your response to your opponent's objection to the emphasis the trial court seemed to put on that point?
Well, I think that he was looking at the overall situation, which was that she'd taken a lot of money out of the property of her own volition, and that having gone through this process, and remember, she went to get the third loan, she was dissatisfied with the process for the prior loans. But nonetheless, she didn't do anything more than just basically put herself in the hands of other people and make no effort to even learn what she was doing. So, she did nothing to try to learn what was happening here. And then she signed her name on a number of things, which wound up being false, where it was very easy for her to see that she was not getting what she claims that she wanted to get from the transaction. So I think it's very relevant, the fact that she'd done this multiple times. And in fact, just in the last 2 years before this.
Well, I don't know that anybody's disputing its relevance. I think the issue is whether it is sort of unassailably relevant so as to foreclose as a matter of law claims of unconscionability or fraud.
Well, I think that you don't get there because the loan terms were fair in and of themselves. And it's a two-pronged test, certainly on common law unconscionability. So in a sense, you don't have to reach that question because the loan terms were fair.
But the CPPA makes knowledge that the consumer will not be able to repay a loan a factor that bears on unconscionability. So what do you do with that? Unless it's focused on Premier at the moment and not your client. It does seem that on what seemed to be undisputed facts, Premier knew this. Maybe you think the facts are disputed. Mr. Knott says that one of the factual issues is whether Premier lied about the income. So maybe those facts are in dispute. But assuming that were resolved in Ms. Archie's favor, would that not point to unconscionability?
Well, again, we don't think it matters when the loan terms themselves are fair, which they were. And again, as we've said, our principal defense on the CPPA is that they're not a merchant in this context. And they got the default. Ms. Archie got her default judgment against Premier. Of course, it's essentially worthless because they're not around anymore. But Premier was subject to be sued on that issue. And if you'd done it earlier, perhaps it would have still existed. But my client's in a different position from Premier at this point.
All right, Mr. Smith, thank you for your argument. Mr. Knott, did you need a few moments?
Yeah, just a handful of points, Your Honor. I didn't hear a defense of Premier's conduct from Mr. Smith. I heard some aspersions on Ms. Archie, but of course, those were the issues that were disputed and that a jury would have had the opportunity to evaluate had it been able to hear testimony from Ms. Archie. It's not correct, by the way, that Ms. Archie received a default judgment against Premier. That didn't happen. For purposes of U.S. Bank and PennyMac, I actually believe that they are merchants. They participate in the supply side of the transaction. I think they've claimed to have made some payments for taxes and insurance and things of that nature to preserve their claim to the property. So they're still involved with this transaction. And I would also point out that, again, unless U.S. Bank is a holder in due course, which it is not, it takes the bitter and it takes the sweet. It has a claim to try to enforce this loan that it purchased, but it is subject to the defenses that Ms. Archie would have had. And again, under the CPPA, Section 3901A5, as well as 3905K1, an action for relief from a trade practice such as this is certainly, I think, a defense to enforcement of an unconscionable mortgage, which this was. As far as the timing of when U.S. Bank purchased the loan, because it's attempting to claim some superior equitable position here, U.S. Bank bought this loan after judgment had been entered for Miss Archie on the statute of limitations. And only subsequent to that did the court reverse that decision. After initially saying in the 2017 hearing that there were a lot of factual issues, certainly as it related to unconscionability, the court then reversed course and found that the fact that Miss Archie had been involved in prior transactions was dispositive. And that is inconsistent with modern management. It's inconsistent with Hughes v. Abel, Williams v. First Government, and other CPPA decisions. Lastly, Mr. Smith took the position that the UCC—
I'm sorry, let me just interrupt. Your last point, the fact that US Bank bought the loan after there had been a judgment for Ms. Archie, this is relevant to, I guess you're saying it's relevant under the UCC, but is it relevant under the CPPA as to whether or not US Bank is subject to defenses?
I don't think it affects the CPPA analysis, again, because U.S. Bank is not a holder in due course, regardless of the timing of when it acquired the loan, but it merely responds to U.S. Bank's attempt to claim some superior equities. It clearly took this loan with knowledge of all the defenses that Ms. Archie had asserted, and indeed, even the judgment had been entered in her favor. And as far as—
yeah, that point certainly goes to the without notice. The language we use under the UCC. I'm not sure what relevance it has to the CPPA arguments, but I take your point that you were responding to the superior equities point. So
yes, Judge.
All right, go on, please.
And as my last point, Mr. Smith took the position that the UCC has nothing to do with this case. I wonder why he's citing it in his brief at page 22. PennyMac and U.S. Bank relied on the UCC to establish their standing as holders to enforce this note. We raise factual issues with regard to that as well, which we've set forth in our brief. But without the UCC, U.S. Bank has no claim here. This is clearly an action to enforce Ms. Archie's obligation on the note. They're seeking to sell her house and use the proceeds to pay off the note that they claim she owes. And so the UCC is directly relevant here. And it permits—
You do agree, though, that this is an in rem action. I did not see any suggestion that U.S. Bank is attempting to recover against Ms. Archie personally, such that if there were a deficiency after a foreclosure sale, they would come after her for that, or she would be liable for that.
They have disclaimed any intent to do that, I believe. They are seeking the remedy of foreclosure to satisfy her obligation on the note. Our view, of course, is that that's time barred under the UCC. But at its bottom, as this court recognized in Yasuna v. Miller, a foreclosure action is still an action to enforce an obligation on a note. The note takes primacy. The deed is subordinate to the note, and the deed can be viewed as part of the same document. And so to say that the UCC and its law governing negotiable instruments has no application here, in my view, is just wrong. The court should either enter judgment for Ms. Archie on the statute of limitations or reverse for a trial on the many fact-bound defenses that she raised. Thank you.
All right, thank you, Mr. Knott, and thank you too, Mr. Smith. The case is submitted.
Thank you.
And the court will stand adjourned.
This court is now adjourned.